India is the world's largest democracy and a global tech powerhouse. Yet it leads every nation on earth in internet shutdowns. The legal tool that makes this possible isn't a modern surveillance law. It's a 140-year-old British statute written to regulate telegraph wires. Under this colonial relic, entire regions have been cut off for months, 213 days in Jammu and Kashmir, 208 days in Manipur. How does the Victorian-era law allow a 21st-century democracy to pull the plug on millions of its own citizens, without a judge's signature? The answer lies in an emergency provision designed to control crowds, now repurposed as a digital kill switch. The power to disconnect millions starts with two colonial-era laws, both born in the late 19th century when the British Raj feared rebellion. The first is the Indian Telegraph Act of 1885, passed to give the colonial government exclusive control over telegraph infrastructure. Back then, telegraph meant copper wires carrying Morse code from one military post to another. Today, the Indian state argues that the same law covers fiber optic cables, mobile towers, and broadband, the entire digital backbone of the country. That interpretation alone allows the central government to order any internet service provider to suspend connectivity with a simple letter. But it is the second law that makes shutdowns a truly local weapon, Section 144 of the Code of Criminal Procedure. Drafted as an emergency provision to prevent riots, it empowers any district magistrate to ban gatherings of 5 or more people for up to 2 months. Crucially, the same section can be invoked to shut down all internet, mobile data, and SMS if the magistrate decides they could cause obstruction, annoyance, or injury to any person lawfully employed. There's no legislative debate, no automatic judicial oversight. A single administrative officer, often with no technical background, can sign an order that silences an entire state's digital life. This 19th century apparatus, designed long before radio or television, now serves as the default mechanism for digital blackouts in the world's largest democracy. How does this actually work on the ground? When a protest flares up, or ethnic tensions rise, a district magistrate can draft a shutdown order under Section 144. The order is then sent to local internet service providers, often within hours, demanding an immediate suspension of mobile data, SMS, and sometimes even fixed-line broadband. The Indian Telegraph Act provides the legal backing for the central government to direct these same providers, but in practice, the vast majority of shutdowns are ordered by India's 28 state governments, not New Delhi. And while the Information Technology Act of 2000 gives the government the power to block specific websites under Section 69A, citing threats to sovereignty or public order, that process at least involves a committee. Shutdowns under Section 144 bypass even that. There is no appeals process for the millions of users affected. The OpenNet initiative found that Indian filtering is selective in political, security, and social areas, but shutdowns represent a total disconnect, not mere filtering. When a magistrate signs the order, an entire region vanishes from the global internet. Nowhere is the scale of this power clearer than in 2 recent, record-breaking blackouts. In August 2019, after the Indian government abrogated Article 370, which gave special status to Jammu and Kashmir, the region was placed under a total communications lockdown. It became the longest internet shutdown in the history of any democracy. For 213 consecutive days, millions in Kashmir were cut off from the web, no news, no banking apps, no emergency calls. Journalists could not file stories. Hospitals struggled to reach staff. Then, in 2023, the northeastern state of Manipur erupted in ethnic violence. The state government imposed a shutdown that lasted 208 days. For over half a year, families couldn't coordinate safe passages, and critical rescue efforts were hampered. These weren't brief curfew-style restrictions, they were months-long information sieges. And they demonstrate a crucial shift. What was once a temporary public order measure is now being deployed as a sustained suppression tool, strangling entire populations from the digital world. While the laws are old, their use has exploded under the Modi administration. In 2018, government blocking requests to social media platforms stood at around 6,000 per year. By 2024, that number had more than doubled to 12,600. Then, in October 2024, the Ministry of Home Affairs launched the Sayog portal, a centralized digital platform that allows law enforcement agencies across the country to submit takedown requests directly to intermediaries. The effect was immediate. In 2025, the number of blocking requests nearly doubled again, reaching 24,300. But it's not just the volume that's changed, it's the speed. Since February 2026, the compliance window for online platforms was slashed from 36 hours to just 3 hours, the shortest government-mandated takedown timeline anywhere in the world. This means a district magistrate can order an internet shutdown, and within the same morning, social media companies must erase any content deemed threatening to public order. New intermediary guidelines, amended in 2023 and again in 2026, raise the stakes further. If a platform fails to comply within that 3-hour window, it can lose its safe harbor protection, making it legally liable for all user-generated content on its service. The system has been calibrated for speed, minimal friction, and zero judicial delay. So what does this mean for Indian democracy? According to Freedom House's Freedom on the Net report, India is rated partly free with a score of 50 out of 100, ranking 37th out of 70 countries. Reporters Without Borders placed India 157th out of 180 nations in its 2026 Press Freedom Index, classifying the press freedom situation as very serious. A 2022 quantitative study covering the years 2012 to 2020 found that districts and states ruled by the Bharatiya Janata Party, or BJP, experienced significantly more internet shutdowns than non-BJP states, and these shutdowns were overwhelmingly imposed in response to protests, not riots, but peaceful demonstrations. The colonial-era legal architecture is not politically neutral, it is being deployed asymmetrically against dissent. And yet, there is a faint pushback. In March 2024, the Supreme Court of India stayed the notification of a government-run fact-check unit that would have been empowered to identify and mandate removal of fake, false, or misleading news about the central government, a move that critics called a potential state censorship machine. The case is still pending. It represents a constitutional question hanging over a system that has already routinely disconnected millions from the web. Whether the world's largest democracy ultimately upholds the digital rights of its citizens or cements this legal loophole will define the future of internet freedom in the global south. The colonial wires that once carried telegrams now form the legal scaffold to sever a billion people from the global information grid. India's shutdown crisis is not a technical glitch, it's a design feature inherited from empire and sharpened by decades of executive overreach. As the Supreme Court weighs its next move, the question hangs in the air: can a democracy survive when the very tool that connects it can be silenced at the stroke of a district magistrate's pen? For now, the 19th century lever remains ready, ensuring that anywhere in India, a single official can turn off the internet with less oversight than it takes to issue a parking ticket. The global implication is clear: if the world's largest democracy can't break free of this colonial loophole, what hope is there for digital rights elsewhere?